Sir, I think it's time to go live.
Sorry?
So
We think it's
10:55.
good time that we go live now.
Yes. Just give me a second. Silent.
तो मैं ऐसे उठा के
मुझे
इन सारी को ना थोड़ा उधर पुश कर दो फिर आप और दे दो मैं ऐसे
इसको भी निकाल दो।
इसको
इसके बीच में तो है नहीं कोई, बस ठीक है, डन हो गया।
हाँ इसको अच्छे से कर दो।
हाँ ठीक है, दे दिया। हल्का सा मैं उधर हो जाऊंगा, हल्का सा जो मैं हूँ आप सीट ही खिसका डालेंगे। that will be better.
No, what is? आपने खोल दे रहे हैं, पहले लोगों ने लॉगिन किया है। अजय सफरवाल
Can't hear you.
Good morning, everyone. I think a lot of you have already joined in, and just give us, I think, another 2-3 minutes. We are scheduled to start at 11. So by 11:01 sharp, we should start the discussion and move on. Thank you. संजीव की नीचे की आ गया।
हाँ जी।
हो गया 58 पे। सुधीर जैन कर लिया ज्वाइन। Friends, just give us 1 more minute and then we'll start. You can start. Hi, good morning, everyone. This is Aditya Kumar from Ashwani and Associates, and would like to welcome you all to today's session. To begin with, let me just check if you could just give a thumbs up saying I'm audible, the screen is viewable, and if you just give a in the Q&A or the chat box, if you can just mention, that'll help us to start the proceedings. Okay, audible, fantastic. So I would really like to thank you all for joining in such great numbers. I can see hundreds of you join in from all over the country. I'm really thankful for this overwhelming support provided by all of you. And I also hope and pray that all of you and your families are keeping well. It has been almost 6 months of battle with COVID that we've been fighting. And what I have observed in this span is that most businesses are trying to pivot towards digitization. And as most organizations are still trying to come to terms with digitization, we saw our government take a major digital transformation move in the income tax assessments and appeal process, which is what our today's webinar is all about. In fact, I did a brief study, and what I could find out was that only Singapore and Australia are the two countries which have a somewhat remotely similar process than what we are planning to embark onto. So the outline of today's session would be as follows. We would have the opening remarks by Sanjeev ji, who would give, and then that would be followed by a walkthrough and discussion by CA Uditi Jain and CA Bhavesh Jindal, who are both part of our young and vibrant tax and regulatory team, specializing in international tax, transfer pricing, and tax litigation. And after their walkthrough, we will seek Mr. Ashwani Kumar's comments and deliberate with him on some key issues that emerged from the scheme, followed by Q&A from the audience. So friends, please feel free to type in your questions in the Q&A box that you see in the toolbar below. With this, I would now hand over the proceedings to Mr. Narayan.
Thank you, Aditya, for the brief but very lucid introduction. Good morning, friends, colleagues, and associates. I think quite a large number have already joined to this webinar on this bright, sunny morning. It's sunny in Delhi, on the new phase of tax litigation, faceless assessment and appeals, which is a tectonic shift, a radical shift at that, in the way, in the entire ecosystem in which the direct tax system has been functioning in India for decades altogether. August 13, 2020 will go down as the Euclidean Eureka moment in the history of tax litigation in India. With one stroke, akin to what we had demonetization a couple of years back, gone are the days of filing reams of paper in the department, roaming around in the corridors, sending chits, waiting, fidgeting in the seats, waiting for your turn, getting impatient, fretting at the delays, sipping endless cups of tea with your colleagues in the departmental canteen, gossiping about the department and the various functionings, Gone are the days to be replaced. We had a marginal shift toward the e-assessment in terms of we started scanning papers instead of filing them in paper form. That is a gradual shift, but in one stroke, our Prime Minister Narendra Modi on 13th August radically shifted the entire scenario to a paperless system. The issues which had become ingrained in our mind, we had got used to a certain procedure, a certain way of working, a certain time frame. We had built up relationships in the department over a period of time. All that would become history and sought to be replaced with a paperless scheme and a paperless, faceless process, wherein neither the assessee nor the tax practitioners will know the identity of the person involved, both at the assessment stage and at the CIT appeal level. Now, we knew that the assessment was going to get faceless very soon, but the move to a faceless CIT appeal has come suddenly as out of board from the blue. So it's time that we embrace the speed and the change and take it as a fact of life and as a reality. For the tax practitioners and those affected by it large, the effect of the dose, as I already mentioned, has been akin to that of the demonetization served on the economy a couple of years back. The change which affects a wide swath and cross-section of the society, in the face of that, it is necessary for all of us, the professionals, assessees, and even the departmental officers to recalibrate and reorganize themselves to deal with the new paradigm and the radically changed landscape and the operating ecosystem. Now, in this respect, a lot of legal, procedural, and technical and infrastructural issues will arise. How will the backbone function? What is the manner in which things are going to be uploaded? What is the platform that is going to be used? As the department unleashes this new technological platform, it will have to be powered by a sense of dynamic adaptability to be able to deal with the diverse profiles of the assessees and even sometimes their conflicting demands. As professionals, while grappling with this altered scenario and the legal and professional issues that are likely to arise, both in the medium and short, medium, and the long term, we will have to develop the relevant technological capabilities, be up to speed to perform our professional duties, and discharge our responsibilities. The change is radical, and it will involve a radical change a total change of the mindset in the terms of the functioning which were used to with the department. Of course, not only on the part of the assessees, the tax practitioners, the assessees would also have to adapt themselves to the change, to not only ensuring that the proceedings are attended to on a timely basis, but also in putting in place a suitable mechanism to ensure that there is regular compliance. By that I mean, in an electronic scenario, being up to date with all that is happening and all that will happen. It's very necessary that your accounting and financial systems are updated in a manner so that they are backward integrated with those of the department. We'll deal with more of these issues later as we come into the technical section of the webinar. In this scenario, our team led by two bright young sparks, Uditi and Bhavesh, we have compiled a presentation which seeks to provide a broad overview of the issues that we are likely to face, based on admittedly whatever little information that is available in the public domain. We may gladly admit the exercise is by no means exhaustive and complete, given the novelty and the complexity of the task and its boundless enormity. Questions are bound to arise, bound to remain unanswered, and bound to lead to more confusion. But the idea is to share thoughts, foster discussion, and deliberate, and to enable widespread dissemination so that there can be a wider platform on which issues can be discussed and taken forward and maybe dealt with the department at a later stage. Thank you all for this patient hearing. And over to you, Uditi and Bhavesh, for the rest of the session. Thank you so much.
So before Uditi and Bhavesh take over, I just wanted to launch a small poll. It will take you just 10 seconds to respond to that. So can you all just vote to this, how well aware are you of the faceless assessment scheme? That will sort of enable both Uditi and Bhavesh to elaborate accordingly. Yes, thank you. I see a lot of votes are coming in. Fantastic. We'll just give it another 10 seconds and then we'll publish the results. Wonderful. So we'll wait for 50% of you have voted. And so we just end the poll there, and here we share the results. So I think a large part of the audience is still not aware of what the scheme is, and I hope that the presentation given by Uditi and Bhavesh will help us understand the scheme better. Over to you, Uditi.
A very good morning to all. Thank you, sir. Hi, today I, Uditi, and my colleague and friend Bhavesh, we're going to help you walk through the Faceless assessment scheme that has been recently launched by the central government, and that is the CBDT. Okay. While the world is moving increasingly towards a customer-centric focus, and in this era of rapid digitalization, even the Indian tax administration is taking its steps in making the Indian taxation more taxpayer-focused and taxpayer-friendly. This is expected to improve the way the tax authorities work with the taxpayers. This newly launched Faceless assessment scheme and appellate procedure is a bold move by the central government and will bring in a paradigm shift from the traditional manner of conducting assessments to being driven by technology completely. Now, how far does this scheme goes, that only times will have to tell. So let me help you quickly walk through. So let me help you quickly walk through the backdrop and the scope of the scheme. So how has the scheme evolved over the different years? October 2015, with the advent of the e-governance drive of the central government, the CBDT in 2015 launched on pilot basis the process for undertaking various proceedings and hearings under the income tax law on emails on voluntary basis. April 2017, the e-proceedings module was formally launched on the Income Tax Business Administration portal, which could enable a host of proceedings under the income tax law using electronic means as an interface between the taxpayer and the tax authorities. Finance Act 2018, through the insertion of subsections 3A and 3B to Section 143, brought in a legal framework for the automation of various processes involved with assessment and authorized the central government to implement the e-assessment scheme. I have now shown the legal text of this scheme. Reading through, we get to know that the central government is now empowered to make a scheme for faceless assessments so as to ensure a better efficiency, transparency, and accountability in the assessment procedure by virtually eliminating the interface between the assessing officer and the assessee to the extent it is technologically feasible, by optimizing the utilization of resources and introducing a team-based assessment with dynamic jurisdiction. So unlike the current scenario where the assessment used to be at the sole discretion of the assessing officer, now there is going to be a team-based assessment which is likely to result in the assessment being decided completely on the merits of the case of the assessee. The central government is further empowered to issue any directions, modifications, or adaptations in the implementation of this scheme. Two important updates that the Finance Act 2020 made in this section were that the scope of this scheme is now extended to best judgment assessments under Section 144. Also, earlier the power for the central government to issue directions was up till 31st March 2020. Now this has been increased by a time frame of another 2 years, and accordingly the central government is now empowered to make directions, to issue directions up till 31st day of March 2022. September 2019, e-assessment scheme was formally launched by way of issue of notification number 61 of 2019. A total of close to 58,000 cases were taken up under this scheme. The Finance Act 2020 introduced provisions enabling the central government to develop a platform for conducting faceless assessment scheme even before the first appellate authority. So here again, I would like you to go through the legal text, and as we will read, you will get to notice that this section is exactly a corollary to the section 143, 3A and 3B that we just discussed. The only change that is there is that this provides a legal framework for the disposal of appeals by the Commissioner of Income Tax Appeals in an electronic manner. August 13, 2020 came as a surprise for all concerned when our Honorable Prime Minister, Shri Narendra Modi, formally launched the transparent taxation platform encompassing faceless assessments and faceless appeals using a technology-driven interface. So let's see as to what comes within the purview of the scheme. This scheme now extends to all the current assessment or reassessment proceedings that were being carried out before the jurisdictional tax authorities. The only exclusions that have been provided are with respect to the cases that are assigned to central charges, which is likely to apply to assessments in the case of search and seizure actions. And the other exception that is provided is with respect to the cases assigned to international tax charges. This has been provided by way of, these exclusions have been provided by way of issuance of order by the CBDT dated 13th August 2020. However, further clarity will be required to see as to what exactly does this would imply. Now, let me help you walk through the functional structure or the operational morality of the scheme. So as you can see, the National E-Assessment Center is the authority, which is the supreme authority under the scheme, which is the nodal agency for all the communications that will pass from the assessee to the assessment units and also amongst the various units of the Regional Assessment Center. Below the NEAC, there will be REACs. REAC is nothing but a collation of the various assessment units, verification units, technical units, and review units under the scheme. The entire communication would be electronic under the scheme, and whatever communication will pass from the assessing office, from the assessee to the assessment units will only be through the NEAC. Even for communication amongst the various units of the REAC, only NEAC will facilitate the medium. So now let me help you look through the functions of the NEAC. So as discussed, NEAC would be the nodal agency for conduct of e-assessments under the scheme. It has been vested with the power to make assessments in accordance with the provisions of this scheme. Now here, I would like to cite an example. Just like whenever there is a mishap in an airplane, the first thing to look for is the black box of the plane. This is because the black box stores all the data in relation to the airplane and provides vital information in case there is any mishap. Similarly, the NEAC is the black box of the faceless assessment scheme. I'm saying this because it would maintain an audit trail of whatever events that will happen in the scheme and would be a powerhouse of information in this faceless assessment scheme. It would be a single point of contact for the taxpayers. Now, if you look from the point of view of the taxpayers, the NEAC is the new face of the assessing officer. So for the taxpayers, the only medium that you get to interact with is your computer screen, which is being operated by the NEAC on the other hand. As I mentioned earlier, the NEAC will be the point of contact for communication between different units that encompass the REAC. It would facilitate the issue of notices and communications electronically. The NEAC is also empowered to specify format, mode, procedure, and processes after necessary approvals from the board. Now, let us understand about the various functions that are performed by the various units encompassing the REAC. So first we look at is the assessment unit. The assessment unit is formed to facilitate the conduct of e-assessment by performing the function of assessment. It is important to note that 95 assessment units have been identified under the scheme. So as the name itself suggests, assessment units will perform functions in relation to assessment of a particular assessee. This would primarily include identification of various points or issues that may be material for the determination of any liability, including refunds under the Act. It would also be empowered to seek information or clarification from the assessees in relation to various points or issues identified. Similarly, it would be also empowered to seek information from the technical unit, which I will discuss later, for conducting assessment and seeking technical advice in relation to any particular matter that may arise in the case of an appellant. It will do an analysis of the material that has been furnished and accordingly will frame assessment. Next we look at is the verification unit. So verification unit, again, the name itself suggests that it will facilitate the conduct of e-assessment by performing the function of verification. A total of 35 verification units have been identified under the scheme. Broadly, the functions will include inquiries, cross verifications, and examination of books of accounts and witnesses, and also recording of statements. All these functions, including any other function that may be required for the verification unit to verify the case of the assessee, will be taken up by the verification unit. Technical unit. The technical unit will help the conduct of e-assessment by performing the function of providing technical assistance. Accordingly, it will provide technical assistance and guidance on any legal, accounting, forensic, information technology matters. Further, it is also empowered to do valuations, audits, transfer pricings. It would be also empowered to do valuation and audits, and also help in providing advice on the various transfer pricing and data analytics matters that may arise. Any other matter on which the assessment unit requires a technical advice on will be provided by the technical unit. It is again important here to note that there are only 4 technical units that have been identified under the scheme. And these have been formed as the 4 metro cities of India, which are Delhi, Mumbai, Kolkata, and Chennai. Coming up next, let's look at the functions of the review unit. The review unit will facilitate the conduct of e-assessment by reviewing the draft assessment order that has been passed by the assessment unit. A total of 20 review units have been identified under the scheme. Functions will broadly include reviewing and checking whether the relevant material and evidence has been brought on record, whether the various points of facts and law have been considered in framing assessment, whether the additions or the disallowances that have been made have been duly discussed in the draft assessment order, checking if the various judicial decisions that have been relied upon are correct in the case of the assessee, checking if the assessment has been framed on merits, and also checking the arithmetical correctness of any modifications that have been proposed. So this is broadly the functional structure that is designed under the scheme. Now, I would like to call my friend and colleague Bhavesh to kindly take up the further aspects in relation to this faceless assessments and appeal scheme. Please, Bhavesh.
Thank you so much, Uditi, for enlightening us all about the functional structure of the faceless assessment scheme and how the scheme has evolved over time. Now, when we are well-versed about that, now it's important that we understand the overall mechanism under the faceless assessment scheme. Our discussion on the procedural aspects will be further divided into 4 categories. First, we'll discuss about the assessment, how the workflow will be undertaken. Thereafter, we'll discuss about the appellate proceedings. Then some personal hearing aspects, one of the main questions that all the stakeholders might be having. And finally, the mode of communication that is going to be opted under the current scenario, or the future scenario. As far as the assessment proceedings is concerned, we will deliberate and study as to how the assessment shall be conducted under this scheme and when the powers of the jurisdictional assessing officer resume. Assessment under the scheme, my friend has already discussed that NEAC shall be a single point of contact between assessee and assessment unit. So therefore, on the face of it, what we will see is the communication between NEAC and assessee. But in reality, a lot goes behind the scenes in order to finalize the assessment, which we will discuss in this slide. As understood, that NEAC has been vested with the jurisdiction or powers to make an assessment under this scheme. Thus, first and foremost step that shall be wherein a notice shall be issued by NEAC under section 143(2). As we understand, current notices under section 143(2) are issued by NEAC as a notice under section 143(2), read with section 143, subsection 3A and 3B, empowering NEAC to make an assessment, which have already been discussed by my colleague in earlier slides. The assessee may then respond to notice under section 143(2), after which the case shall be assigned by NEAC to any assessment unit under any REAC by way of an automated allocation system, which is an algorithm-based system having no human intervention whatsoever. Once the assessment unit has been assigned a case, it shall then facilitate NEAC in making assessment, and for the purpose of same, it may ask for additional information, or it can also seek assistance from technical units and verification units as the case may be. As already discussed, that the entire process shall be routed through NEAC, therefore the notices under section 142(1) asking for further information shall be issued by NEAC to the assessee. The assessee may then either file the response within the time specified in the notice, or it may also seek adjournment under this new scenario, because this the provision of seeking adjournment was not there as far as the e-assessment scheme, which was launched in September 2019 is concerned. In case no response is being furnished by assessee in response to the notices issued, NEAC may further proceed with the best judgment assessment and issue necessary show cause notice thereto, an amendment which was also brought into place in the Faceless assessment scheme in August 2020. All the responses filed, including the information, documents, evidences filed by the assessee, will be forwarded by NEAC to assessment units. Similarly, the reports from technical units or the verification units shall be forwarded by NEAC to the assessment unit. Assessment unit, after taking into account all the available material in hand, issue a draft assessment order. Now, the very important question which comes here is, it is a draft assessment order. And in case where no response has been filed by the assessee, a draft assessment order to the best of its judgment under section 144. One thing which is to be emphasized here is that assessment unit shall provide the details of penalty proceedings to be initiated therein while making the draft assessment order. NEAC will then examine the draft assessment order on a basis of a risk management strategy specified by the board, including an automated examination tool, and will further decide whether it will finalize the assessment as per the draft assessment order, or issue a show cause notice in case a modification to the return of income is proposed. NEAC shall serve the show cause notice. Assessment unit has no authority to issue a show cause notice. Or it can also further assign the case to a review unit under any REAC. Now, in case where a show cause notice has been served by the NEAC, assessee may file the response or may not file the response. In case the assessee files the responses shall be again forwarded by NEAC to assessment unit, and NEAC will then finalize the assessment order on the basis of a revised draft assessment order that will be received by assessment unit after taking into consideration the response filed in response to show cause notices. The entire process of allocation is automated, and the allocation can be made to any unit under any REAC. Therefore, it is possible that if SSE is based in Ludhiana and its assessment unit is based in Delhi, the RU or review unit is somewhere in Kolkata. And it is not necessary that assessment unit, verification unit, or technical unit, as the case may be, will be under the same REAC. Once the review unit comes into play, there are further proceedings which shall follow, wherein the review unit can either accept or concur with the draft assessment order, or it can not disagree with the draft assessment order issued by assessment unit. Now, in case I would like to draw the attention of my viewers towards this slide. If a review unit does not agree with the draft assessment order and there is a difference of opinion between the assessment unit and review unit, then NEAC, which will assign the case to a new assessment unit. What I'm trying to emphasize here is, in case the review unit is not agreeing with the draft assessment order, it will further include another assessment unit which has actually not made the assessment. Now there is this new assessment unit into picture. Thus, in our earlier example, it is possible that assessee is Ludhiana based, AU is Delhi based, review unit is Kolkata based, whereas the new assessment unit is Mumbai based. However, we cannot rule out the possibility that there is 1 in a million probability that all units can also fall under the same RESE. Then the new assessment unit, after taking into account modifications suggested by review unit, send a final draft assessment order to NEAC, and NEAC shall then again opt for either option 1 or option 2 as enumerated above. Either it can finalize the assessment order or issue a show cause notice. As earlier, the show cause notice was not issued. So what we understand is, whenever modification to the return of income is proposed, NEAC will definitely issue a show cause notice. Now, further, if the review unit concurs or agrees with the draft assessment order, it will again intimate the same to NEAC, and NEAC will again have those two options. Either it can finalize or issue a show cause notice. With this, I conclude the entire procedural aspects as far as the faceless assessment is concerned. I hope I could apprise my viewers and resolve some of their concerns. One more thing which I would like to inform here is that Principal Director General of Income Tax or Principal Chief Commissioner of Income Tax, who is in charge of NEAC, has been vested with the power under subparagraph 2 of paragraph 5 of the scheme, wherein, if considered necessary, they may transfer the case to jurisdictional assessing officer, but for that they will have to seek a prior approval from CBDT. Now, once the assessment has been finalized and the copy of order or the notice has been a notice of demand or notice of initiation of penalty has been given by NEAC, what will happen is, so basically first the powers for the assessment will be transferred to NEAC. Thereafter, NEAC will take up the assessment proceedings under the scheme. After then, NEAC will transfer all the electronic records to back to jurisdictional assessing officer for further compliances like imposition of penalty, launching of prosecutions, recovery of demand, rectifications, representations before the appellate authority, submissions of remand report, or even giving effect to the appellate orders. Now, the question which comes here is, what shall be the jurisdiction of the CIT appeals, or where the appeal shall lie? For that, I would again like to draw attention of my viewers towards this simple slide, wherein it has been depicted that appeal shall lie before the CIT appeal having jurisdiction over the jurisdictional assessing officer. Further, our Honorable Prime Minister in his speech of 13th of August 2020 announced that going forward, all the appeals before CIT appeal shall be done in a faceless manner from 25th September 2020, and necessary amends in section 250 have been discussed by Uditi already. All the stakeholders are eagerly waiting for necessary notifications and guidelines in this regard. Now, as we have discussed the assessment proceedings and the appellate proceedings, one of the major concerns that most of our stakeholders might be having is, what about the personal hearing aspects under this scheme? Wherein, or we can say, where is the personal hearing and how they will be given an opportunity to personally present their case? In this regard, an inherent provision which gives an opportunity to assessee or their authorized representatives in case where a show cause notice proposing modification has been issued. In that case, assessees or the authorized representatives can make a request to REAC for presenting their case through video conferencing modes. Such request will then have to be approved by the Chief Commissioner of Income Tax of REAC under REAC of that REAC under which the assessment unit which was making the assessment is located. And the approval shall be given only in the circumstances which are notified under clause 6B of paragraph 12 of the scheme. Sadly, as of now, no notification has been issued. Also, further, for verification and examination or recording of books of accounts, verification unit shall also conduct the personal hearing through video conferencing mode. There will be no personal hearing. If there is a personal hearing, the same shall be through video conferencing mode. The board is also making a necessary provision so that none of the stakeholders is deprived of the benefit under the scheme just because they do not have necessary video conferencing thing at their place. One of the main objective of the scheme is to eliminate and as far as possible the direct contact between SSE assessment unit and the SSE. Therefore, in order to achieve that, necessary communication shall be done electronically through e-filing portal, wherein the necessary documents and notices shall be placed. However, these notices and documents will have to be duly authenticated. And further, the necessary alerts will also be given on the email of the SSE email, which might be available in the e-filing portal or in the latest ITR, as per the PAN records registered with the Aadhaar card, that Aadhaar card which is registered on the portal, then as per the MCA records or any other email ID that might be available with the IT department. Also, it will send an SMS alert on the mobile registered with the e-filing portal, ITR, or the contact of authorized representative. So there, one more point which I would like to raise here is now in the current scenario of the e-assessment or the faceless assessment, there is this option wherein we can add the authorized representative on the portal itself of the e-proceedings. And that if you add the authorized representatives, then your authorized representatives can also get the necessary notifications. One more thing which has been informed in the scheme itself, that a mobile application will be launched wherein real-time alert will be given. However, we are still awaiting that necessary mobile application. Now, once we have discussed the structure of the scheme, the procedure, and now we have to move forward towards the other aspects of the scheme. Every scheme or every move of the government has some of the pros or cons, and it may be not appreciated by all the stakeholders. For some, it might be possible that pros are catchy, and for others, it might lead to challenges or complexities. Now we shall look forward to some of the pros and cons that prima facie come into our opinion. As we can see that complete automation of the process and a team-based assessment. So we are optimistic that it would lead to assessments being framed on basis of merits. Automated random allocation by NEAC on basis of an algorithm-based system will thus eliminate altogether AO's discretion as far as selection of cases for scrutiny is concerned. No personal appearances of the taxpayer in front of assessing officers. So therefore, it will save a lot of time that could have been wasted otherwise, waiting in long queues or waiting in the corridors of the assessing officer of the department. Has already been discussed in the procedural aspects of the slide. It is quite possible that one assessment unit is in a separate city and its review unit is in a separate city, whereas the new assessment unit is in a separate city. So basically, the assessment is being overall framed in multiple cities. So in that case, again, we are sanguine that objective and fair orders will be served. The department is hopeful that with this transparent mechanism system or the transparent taxation that they have brought into place, they will they will be generating more revenue, tax revenue as it is concerned. Now we'll foresee some of the cons of the scheme. Migration of the ongoing assessments may create inconvenience, as we have seen that 142.1 notices have, in some cases, 142.1 have been issued by the jurisdictional assessing officer. As the e-assessment was selected, the cases taken up for scrutiny were limited. So jurisdictional assessing officers have issued their 142.1 and the responses have also been filed. So therefore, the migration to the new scheme or the faceless assessment scheme may make it difficult. There can be scenarios wherein the assessee, even in the genuine cases, is not able to present its case completely before the assessing officers or before the NEAC. Therefore, the personal hearing aspect that has been made discretionary, it can lead to further issues. As we have seen in filing the replies of assessment year 18-19, or for that matter, even for 17-18, the limit of filing the response in one go is restricted to 50 MBs. Therefore, in case where the data is very bulky and a lot of data has to be inputted, it can lead to technical glitches and can also lead to a lot of troubles. Further, again, if the entire procedure is being made automated, it may prove to be prejudicial to the interest of assessee in some scenarios. Now, once we have gone through the entire structure of the scheme and faceless scheme, now it is important to understand how we have to equip ourselves in taking a holistic view of the entire proceedings. Objective of faceless assessment is, to bring under the spotlight specific issues. So therefore, we all are aware as Form 26 is being duly updated and to include the SFT information, that is the statement of financial transaction required to be filed by certain entities under Section 285 BA of the Act. Now, since that information will be available with the SSC beforehand, thus it is important that we all take due cognizance of that information before filing our returns. Further, the powers of verification unit have been they have been entrusted that in case of mismatched SFTs, etc., cross-checking of information has to they can do the cross-checking on information. Therefore, our verification of information becomes even more vital. All the queries are going to be filtered and e-verified by an artificial intelligence and machine learning tool in place, making it much more robust and proactive as against the earlier system in place. Now, going ahead, we have to see what all are the key considerations that all the stakeholders, or what are the investments that we as stakeholders have to make. As seen, there are instances where in the current assessment, the SSA are not even aware that they are being assessed. And in order to avoid such issues, the contact information is ideally required to be updated on the portal itself. As far as the contact information updation is required, you can either choose, you can either update primary or secondary emails, or you can select forwarding of the respective emails to a respective person or might be your authorized representative. It is also important that going forward, since the entire proceedings is to be conducted in a faceless manner by way of an electronic mode, so it is important that to the extent possible, we opt for a cloud-based mechanism wherein sharing of information with your authorized representatives is also very easy, and thereafter extracting that information and putting it online or submitting your responses will also become easier. Then it is important that we as stakeholders, or especially for the SSCs, taxpayers, it is important that they invest in the proper compliance resources so that they do not miss those compliance resources. There are many compliance resources in market already: smart tax, smart TDS, clear text, etc. Based on the size and quantum, you can also get the same customized. Now, when we have discussed what all are the considerations as far as clients are concerned, it is also important that we as professionals and the authorized representatives also make a model approach on how we will approach this faceless assessment. You need to have the standard operating procedures in place so that you address all the questions, including resolution of technical glitches if faced during the assessment. Again, as already discussed, you have to take a holistic view of the entire thing. So you have to take a 360-degree view of the information that is already available with you, and invest in the legal research resources. You can invest in Taxman, Volter Kluwers, etc., so that it gives you necessary information. Now, as far as we've already seen that this entire process is technology driven, so addressing IT literacy and investing in the IT infrastructure is utmost important. With this, I conclude the entire discussion of the faceless assessment scheme. We hope our viewers have a lot to take back and may have a lot of additional queries. We have tried to resolve some of the concerns after an in-house deliberation, and Aditya sir and Ashwini sir will take up those, followed with an open house discussion. Over to you, sir. Thank you.
Thank you, Bhavesh, and Uditi for that lovely presentation, which sort of gives us a complete overview of what the faceless scheme will be like. You have demystified a lot of terms like VU, RU, TU, NEAC. Maybe a lot to take in in a 30-minute session, but you've done I think, fairly good job in helping us understand that. And with that, I'm launching our second poll, for the audience to sort of tell us what is their feeling after hearing both Uditi and Bhavesh as to how successful do you think the scheme will be? Are you ecstatic? Do you have some apprehensions? Would it be a fiasco? So let me give 30 seconds to you to sort of give me an answer, what you feel about it. The poll is coming in and the numbers look interesting. So yes, I think we have about 5 more seconds, and then we'll end the poll. There we go. So friends, I think if you see, I see a lot of people are ecstatic. 50% people are ecstatic. So I like the optimism. Of course, we need people, in that 7% category who feel that it will be a fiasco, or people in the 43% who say they have apprehensions, because it is them who will make this scheme come out to be better. Because any new thing that you start, there will be glitches, there will be issues. So, but on the whole, the sentiment that I'm getting out of the audience is that we're looking forward to such a regime. So with this, I would now sort of take this discussion forward with Mr. Ashwini Kumar, and discuss with him the, what are the, it's been 42 years that he's been into practice. So what is his overall view of the scheme as to how it will be different and how things have changed for him in 42 years with this just one stroke? So over to you, Ashwini.
Thank you, Aditya. Thank you, Sanjeev ji, Uditi, and Bhavesh for making this webinar, I think, very lively. First of all, good morning to all my viewers, and my special thanks to Mr. M.K. Mirani, former chairman of the Settlement Commission, Mr. Siddharth Pradhan, former vice chairman of the Settlement Commission, Mr. G. Ramaswamy, former president of the Institute of Chartered Accountants of India, Mr. R.M. Garg, former director general of investigation in the Income Tax Department, and all my dear friends and colleagues. This new scheme, as we have been told, was introduced by our Honorable Prime Minister on 13th of August, just 2 days before Independence Day. This, as coronavirus has changed the mindset of the world, I'm sure this scheme, which has been launched during this very period, will change the mindset of all stakeholders vis-a-vis the Income Tax Department, the taxpayers, or the professionals. At the outset, I must say that these are challenging times. And as I have always said, challenging times are always times of opportunity. This scheme was earlier launched in 8 cities. The general perception was that this will be brought in another 50 cities. But just by one stroke, our Honorable Prime Minister brought it throughout the length and breadth of the country, starting from Jammu Kashmir to Kanyakumari, and from Northeast to Kutch. Each and every place, even at the remotest place, you can say, in this vast country, we will be now grappling with the tax problems under the new faceless regime. The first question which comes to anybody's mind is whether this scheme is good or this scheme is bad, or what is the instant reaction. I will say that all schemes, all notifications, all government proposals are good or bad as we understand them. But the main issue is that they are good or bad, they are made good or bad by the people who man them. Because the regulators, the government has come out with a new scheme, and each one of us must accept this, that this is now going to stay. It is not that it has been done in piecemeals or as a pilot project. Whatever pilot project the government thought it was undertaken earlier, but now this scheme is going to stay. there are many issues which come to my mind, because what we have been hearing throughout is that the stress of the government is not on assessment. It is on compliance, voluntary compliance. Yes, that is very well taken. But if we go through the mechanism of the scheme, that theory doesn't sound to be correct. Why I say so? Because if the stress of the government is not on assessment, then why 2/3 of the workforce has been transferred to the assessment procedure? Only 1/3 of the workforce remains in the residuary charge, which is the territorial jurisdiction for all assessees. Because if all of us have been through this department, through these tax matters for umpteen number of years, and I think each one of you will second me on this, that grievance of the assessee is not vis-a-vis the assessment. It may be only a specific person wise, but general grievance of the assessees is with respect to the miscellaneous matters. That is rectifications, refund applications, appeal effects, outstanding demands. Now the latest grievance of assessees is the demands created by CPC, for which you have to apply for rectification with your territorial assessing officers. So these are the issues which actually trouble the general taxpayers. But for all that, we have now, the government has sanctioned only 1/3 of the total workforce, which I feel will further add to the grievances of general public. So this issue, I think, needs to be addressed by the government. Yes, no doubt, faceless assessment. I think just a small clarification which I will like to give, because Sanjeev ji was mentioning in his opening remarks that it will be faceless both qua the assessee and qua the assessing officer. I think that is not the right thing. The department sitting in the assessment unit or verification unit, they will certainly know which file they are dealing with. It is not like a secrecy roll number that you will remove the roll number and the answer sheet will come to you. All the information will bear our name. In any case, will bear our permanent account number, so that the persons performing their responsibilities in the various units, they would at least know the face of the assessee. But yes, the assessee will not know the face of the department.
Thank you. I think that's
yes,
that's a different.
No. I think that at least I think that is my view, and I'm quite clear on this. Then now another thing which comes to my mind is that so much the scheme is, I know every time the government tries to make a scheme, tries to make it simpler, but I do not know why, because of various glitches, it turns out to be quite a complicated one. If we look at this scheme also, there are assessment units, there are verification units, there are technical units, there are review units, and then all manned by a group of officers. I think all our officers who are selected by a competitive exam undertaken by the government of India, they in their own right are very competent. And what happens is that when too many people get together, then sometimes it becomes a game of one-upmanship. And when it becomes a game of one-upmanship, who is the sufferer? I think it will be only the assessee, none else. Yes, the saving grace here is, as has been said, as is being propagated, that now the assessments will be only on specific information based. They will not be general general assessments, in the sense that no general inquiries. It will be only specific information based selection by the NEAC. So if that be so, that's all right. But still, I feel the entire structure has been made so complicated that and so many people involved. You just look at one file, it will pass through how many officers? First, the assessment unit, there will be a group of officers. Then there will be a verification unit, another group of officers. Then a technical unit, which has all the powers to give you technical information. Again, another. Now, what do we feel? I do not know what was the intention of the government, that the assessment unit is not versed with the technical aspects, is not versed with the verification aspect. But still, let us see, let us be optimistic about this. I'm sure something good will come out, but these are some of the areas which certainly come to my mind, can create some problems, particularly for the SSCs. Because how will there be a finality? After all, assessment unit to the verification unit to the technical unit, and then ultimately to the review unit. Now, when we talk of the review unit and the draft assessment order, I am reminded of section 144B, which used to exist under the statute, which was done away with effect from 1489, I suppose, wherein the provisions were identical, that if during the course of assessment, the assessing officer feels that the total assessed income, that the difference between the returned income and the proposed assessed income is above a particular amount, then he was duty bound to send a draft assessment order to the assessee. And assessee could respond within 15 days by filing the objections. The senior officer at that time, the inspecting assistant commissioner, used to give an opportunity of hearing. According to my humble view, it was only a multiplicity of proceedings. Nothing good came out of it. And that is the reason it was done away with. And now, again, we have again come back with the same proposal, which existed under the statute earlier. And I do not know if something good comes out of it. But my humble experience says that as the higher approvals are required, it is generally no relief comes to the assessee. We have seen, and most of you would have seen, the assessments under section 153A, which requires statutory approval of the joint commissioner or the additional commissioner, or in many other cases. Let us take example of 144A, wherein you can seek the instructions of the senior officer, directions from a senior officer. Generally, when too many people get together, it is the assessee who suffers. That is my. Let us take the example of a dispute resolution panel. Now, dispute resolution panel is a panel consisting of 3 senior commissioners of income tax. But according to my humble view, it is also not doing the right service, which was visualized, that when 3 brains will sit together, only the right thing will happen. But I am sure each one of you participating today would endorse my feelings that that is also the purpose of that has not been served, because in the dispute resolution panel also, most of the additions are just proposed. Whatever comes from down below, it is generally the same thing is followed. Now, in any case, all these things which I'm just mentioning, I'm sure with the passage of time, as we keep on deliberating, as the government comes to know of all these issues, there would be some changes. Because if we go back to Form 26 AS, when it came there were so many hitches and glitches because your TDS was not reflected there. But now, after many years, I feel it is a great service to the taxpayer, because from just a simple click of a button, you can know what is the credit to your account and who is the person who has deducted your TDS and has not deposited. So it is very good. Otherwise, people used to run from pillar to post collecting form number 16A. The banks the banks always faltered in not giving the form number 16A and many other places. So it is a great, I should say, at present, we can say it's a great achievement as far as 26AS is concerned. And likewise, this scheme also, I'm sure, will certainly help assessees in the long run. These are some areas which I just mentioned are the areas wherein some problems, at least to my mind, are likely to arise. Now, I must say that the example taken by Uditi, terming the NEAC to a black box, is very apt, because this will contain, as it is said in the scheme, that is the storehouse of all information, because the entire trail of the proceedings will be available there. Now, the other issues are that is joint responsibility, as I have already discussed. Now, some issues which come to my mind technically, that what will happen to 144A?
That's a question that has been asked also. By
Yes. Now, my humble submission is that as far as 144A is concerned, I think it loses its significance and importance, because because it is in the act, in the scheme itself, in the notification, it is mentioned that the group of officers will be consisted of an additional commissioner of income tax and other officers. So there is no concept of 144A. Now then, when we are talking of group-based assessment, I do not know, but I just heard from somebody. I have not been able to lay my hands on that notification, that under the new scheme, even the principal commissioner of income tax will be a part of the assessment team. If that be so, what happens to 263? Because 263 is a revisionary power which is to be exercised by the principal commissioner of income tax. Who will exercise that power? The territorial commissioner can exercise that power. But if the original assessment has been done with the concurrence of the principal commissioner of income tax, then in any case, I think 263 cannot sustain.
Mr. Singh, he's also raised this very question, that who will complete assessment as a result of order under section 263, 264. I don't think there is a reference to these sections. In
Sir, with due respects, first of all, I must welcome you to this webinar. I had not seen your name earlier. It's a pleasure to have you, sir, along with us. As far as assessment after order under section 263 is concerned, my humble view is that it will go back to NEAC, because all powers of assessment, whether after 263 or the earlier or after 148, they all vest with only NEAC, except search cases and cases relating to international tax. So that is very clear as far as the notification goes. Now, there is another question from a friend of mine from Bombay. They have asked that if the case is sent back by the tribunal to the assessing officer, who will frame that assessment? Because in many cases, the tribunals while passing their orders, sent back the matter, or the High Court sent back the matter. Who will frame the assessment? My answer is the same as was with respect to assessment in response to 263. Assessment will again go back to NEAC, because that is the only mode under which assessments can be framed. There can be now again difference of opinion. Say, let us say in a search case, which was the assessment was framed, that goes to the tribunal and it comes back. Who will frame the assessment? I think the answer will be the same, that here the assessing officer who had framed the assessment earlier may be competent to frame. In any case, these are some gray areas for which a lot of litigation will again emerge. Any other questions? I have some issues, but if you can ask me some questions.
So we've got a lot of questions that have come in from the audience. To begin with, I think Mr. Subhendra Jain from Kanpur, he asks that what is the hardware required by professionals for coping up with faceless assessments? Can you please advise?
Jain Sahab, sorry, I may not be the right person to answer this question. I know you will always come with a difficult question for me. That I am sure, but I think I may not be the right person. But yes, in the coming times, we will all, particularly people like me and you with gray hair, we will have to automate our offices and give chance to the youngsters who are very quick with their fingers on these computers. And that is I think the world is open for them. As far as hardware is concerned, I may not be the right person to answer this.
Right. Then there is a question from, or rather thought from Subhash Jain ji, that all assessees have to keep their mobile numbers and email ID updated on the ID portal. That is absolutely valid.
Yes, that is, I think Bhavesh also mentioned in his address,
yes,
that we will have to keep these email addresses, the mobile phones. In fact, as a professional, I think we need to have somebody earmarked who will keep a complete track record of all these things, because otherwise communication may become a big problem, because this will be an effective service for the department.
Right. Then Mr. Rajesh Jain seeks to ask that where if he wants to file a writ in the High Court during the
proceedings, I just read this.
Court it will lie.
I just read this question. Now, as far as I think the writ jurisdiction is concerned, it is wide open, because I think writ jurisdiction, wherever your territorial assessing officer is there, you can file it in that High Court. Wherever, now, because we do not know where is the NEAC situated or the assessment unit situated, that we are not aware. So the best course open for us would be to file a writ wherever our territorial assessing officer or the territorial commissioner is situated. That is my humble view, because this NEAC is just a sheet, you may say, because it is faceless. So we may not be able to file again in the assessment unit where it is situated, because we will not be knowing that.
And Rahul Gupta from I think Delhi, this is a good question. He says that sharing of papers is one thing, but what about understanding? Sometimes physical presence is required to let them understand your point of view. How understanding will be reconciled between the assessee and the ID?
2-3 things which I will like to mention here. Yes, it's a very valid question. Now, that I think that will that is where your capability will be judged, that how efficiently, in what a crisp manner, and with no ambiguity you are able to furnish the replies. Now, still, if a person does not understand or does not want to understand, that problems can always remain. But your endeavor should be to furnish the reply in a very crisp and explainable manner. That is where the actual, I should say, skill of a professional will be measured in the new this faceless scheme. Right. Now, another question which arises is, how will the assessment unit or the verification unit ask us to produce the books of accounts? Nothing has been provided as such. I do not know whether they want to. Now, everybody may not be maintaining books on a computer. Yes, most of us may be, but still, there is no statutory requirement for an assessee to maintain books on a computer. How will they ask us to produce the books of accounts? Then the problem in our country is that we have so many languages, and still account books are prepared in regional languages. It is not that all account books are maintained in English. They are still maintained in many regional languages. So these questions are still question marks, I should say, because if they ask us to give a link to your SAP or to your computer system, I do not know how they will derive that power. But yes, that can be one of them. Because once they have access to that, then they may use their tools to cull out whatever information they want from the books of accounts. But the first question is, how will they get access to my books of accounts? So that is a very big question mark, at least to my humble understanding. I did not find an answer to that. But let us see how the things evolve with respect to this. And linked to that, there is another issue which comes to my mind, is the provision of section 142(2)(a), that is the special audit. How can they ask anybody to get a special audit conducted when they don't have access to books of accounts? Because where is the complexity? So all these issues are again gray areas, because according to me, asking for audit of books of accounts without having a look at the books of accounts, it may be a difficult proposition.
Great. Rajkumar Agrawalji wishes to ask, will ITAT appeals will also be faceless?
No, there is no such provision. There is no such provision. It is only before the CIT appeals. In fact, another thing which I will like to say about appeals before CIT appeals is also, I read somewhere that there also appeal will be filed wherever my jurisdiction of my territorial assessing officer is, but who will decide the appeal? It will go to somebody else. And there also they are providing this, that it may be decided by a group of officers. So I think our associations, etc., may raise this issue, because the concept of a dispute resolution panel has not been a great success. And so similarly, this concept of 2-3 CIT appeals sitting together to decide an appeal may also not be of much help to the assessee. It will create problems only for the assessee.
Right. I think we are at almost closing of our session.
I think before I close this, I will like to just say that as professionals, as a chartered accountant, our role has become much more important, much more significant, much more responsible. Because if we see the entire gamut of things which is happening, the government is trying to rely a lot on the various reports, the various certificates, the audit of accounts which we furnish to the government under various categories, maybe tax audit, maybe special audit, in whatever way we are. And in fact, even the filing of the return, because these are the issues which will have a great bearing in the times to come as far as the assessment of income is concerned. Why a case has to be selected and why not? What is the information with the department? Yes, undoubtedly, lot of data is available with the department. There are no two opinions. But how they marshal that data, then how they collate it with our information in the return or in our accounts. So that will be very relevant. So as a professional, I think we have a great opportunity that as Sanjeev ji was mentioning, that we were wasting a lot of time going to the department, just strolling through the corridors and waiting for our turns to come by giving a slip at different places. So we will be saving all that time. We can sit in our offices, and now the world is wide open. Now I sitting in a small place, let us say Malerkotla or Ludhiana, I can sitting here, I can work for any client in the country. I can work for a client in Kerala, for a client in Bombay. So because the entire thing is to be passed on only with the help of this digital information. So we have lot many opportunities. There are challenges, but I think for us, it is time that we face these challenges and make the best use of the opportunities that are available to us. And anything else, if anybody wants to?
Amarjit ji has raised his hand. If you want, we can bring
Yes,
him
yes. Amarjit ji, why not?
We can allow him to come in as a
Please, please. It's always a pleasure to hear you, sir. Unmute yourself, sir.
Just it lost the contact.
Anji, Anji.
No problem. Yeah. Good afternoon, sir.
Anji, Anji.
Sir, please throw some light about the operation of provision of section 147, 148 in this faceless regime. Then who will be the jurisdictional assessing officer recording the reasons, or the respective JCIT additional or the principal CIT who will be according the approval? So
we will, as I said earlier, we will, every SSC will have a territorial assessing officer. And as far as 148 is concerned, it is only your territorial officer who can reopen your case. And he will be the he will record the reasons with the approval as required under the Act. So there is no difference vis-a-vis the faceless scheme. Yes, once he records the reasons and issues a notice, after that the proceedings switched back to the NEAC. Assessment, job of assessment is only to be performed by NEAC.
That means the residuary jurisdiction will be having the jurisdiction, say in Ludhiana, as PCIT 1 is having the residuary jurisdiction.
Yes,
So he will hold for the whole.
All assessees of Ludhiana.
Okay.
Residuary jurisdiction. That is why I said in my opening remarks that the grievance of the assessees vis-a-vis these rectifications, refund applications, that will further now mount up, because the residuary officers are much less in number and the job in hand may be much larger.
Yeah, correct. Thank you, sir. Thank you very much.
So thanks, thank you very much, everybody, for giving us this opportunity to share our thoughts with all of you. Yes, sir.
Thank you everyone for attending and being part of this session. So we've received some more questions and answer questions, which I think for time we may not be able to take up now, but we'll definitely look at them, evaluate them, and get back to you via email in terms of those questions. Thank you everyone once again for joining us today.
Thank you, sir.
Thank you, everyone.
Thank you, everyone.